Good afternoon and welcome. I hereby open this academic ceremony in which Maria Madalena Barreto Torres de Mendonça Narciso will defend her academic thesis entitled Reviewing the Information Paradigm, the Role of Online Reviews in the Regulation of Information in EU Consumer Law. Dear candidate, may I now invite you to present a summary of your study and the conclusions of your thesis. You have the floor.
Thank you, Prorector. Dear guests, dear committee members, I will now present my dissertation on the role of online reviews in the regulation of information in European consumer law. As you probably guessed, my research concerns the role of information in consumer contracts, and in particular, the role of pre-contractual information in the lives of consumers. Think of when you're booking a hotel. You probably want to ask more or acquire more information about this contract. So you probably ask your colleagues or your friends about opinions about this hotel. You probably look for the main traits of the hotel online on its website. You probably read or get familiar with the main obligations that you have under this contract. Information is what allows us to form our contractual will and our consent. It's therefore the basis of commerce, of trade, and of our economy. It's probably unsurprising to say that the protection of consumers in consumer law, in European consumer law, deals particularly with regulation on pre-contractual information. In particular, the EU legislator or the EU law typically imposes duties to disclose on traders. So it means that traders have to disclose certain pre-contractual aspects or information aspects to the consumer so that the consumer can form its decision. This is called the information paradigm. But just like the long terms and conditions that I'm sure no one here ever reads, the information paradigm has been heavily criticized. Consumers do not always read pre-contractual information. For example, studies show that when terms and conditions or when reading terms and conditions is optional, only around 9% of consumers does so. In addition, even when they do read pre-contractual information, consumers do not always understand what they're reading. For example, if you ever read terms and conditions, you know that often this is written in very technical, highly complex legalese. Or consumers act under biases. For example, they tend to ignore information that is not personally relevant for them. They also struggle with contextualizing information to their personal circumstances. And even though this has been known for many years, a solution hasn't been found either in policymaking or in academic discussion. However, in parallel, in recent years, online reviews have become one of the most important and influential sources of information to consumers. I'm sure all of you have read online reviews at some point. Think of famous review websites like TripAdvisor, Booking.com, Yelp, Amazon, even YouTube. Online reviews convey large amounts of information, but most importantly, they convey a type of information that we're not used to getting through typical disclosures. Advice, subjective information, recommendations from other people. And research shows that over 90% of consumers read reviews before making a purchase or before planning a trip. And you can contrast this with the numbers I just mentioned about online reviews. As an illustration, I refer you to the numbers of reviews on TripAdvisor, over 1 billion reviews to date, and this number keeps increasing at a fast pace. So my opinion is that online reviews are also pre-contractual information, and they form an alternative information paradigm. And this led to my question. If one paradigm seems to flourish while the other one seems to fail, what can we learn from online reviews that helps us improve the information paradigm in European consumer law? And at this point, this is my research question, framed differently. So how can and should online review mechanisms contribute to the information paradigm in EU consumer law? I want to highlight at this point that my research does not concern the role that EU consumer law plays when it comes to online reviews. So for example, regulating their unreliability, but rather the opposite. It focuses on the role that online reviews can play when it comes to EU consumer law. So my research has mainly three pillars. First, I characterize the information paradigm in EU consumer law. Then I characterize the information paradigm in online reviews or based on online reviews. And then I compare the two of them. And I divided my research question in 5 main sub-research questions. First, what is the information paradigm in EU law? Secondly, to what extent is EU law concerned with the quality of pre-contractual information? And when I say pre-contractual information or quality, I mean how good, understandable, comprehensible this information is. Third, how can we frame online reviews as a source of pre-contractual information? Fourth, what are the main differences between these paradigms? And finally, how or what concrete ways are there of online reviews contributing to the regulation of information from a EU consumer law perspective? So to characterize both these information paradigms, I resorted to doctrinal, empirical, and interdisciplinary methods. In particular, to characterize the first paradigm, or the EU law-based paradigm, I looked at nearly 1,500 duties to inform that were scattered across 15 legislative instruments in the European Union, so from EU law. I also looked at case law, for example, from the Court of Justice of the European Union. To characterize the second information paradigm, the online review-based information paradigm, I relied a lot on existing non-legal empirical research, but I also complemented my research with my own empirical observations. I looked at hundreds of reviews that I gathered from 7 platforms that are scattered across 20 different products and services. So now I will briefly answer all my sub-research questions. First, when it comes to the main characteristics of the information paradigm in EU law, it's curious to find that even though the literature frequently talks about the information paradigm, it rarely describes it, but rather uses it as a stepping stone to make further points. And I found this curious because it seems like we're trying to solve a problem without really understanding what the problem is. So I analyzed, as I said, over 1,500, or not over, but just nearly 1,500 information duties, and these are some of the main characteristics. So first of all, most duties concern the disclosure of objective information on the main characteristics of the product or the service or the counterparty. Secondly, there's a privileged protection of higher risk-taking consumers. This means consumers, for example, in sectors like credit, mortgages, or insurances. Then there's also a privileged disclosure on aspects related to monetary aspects of the contract. This means anything related to costs, for example, or how to calculate these costs. I also identified 22 different modalities of transparency, and by this I refer to these typical duties of disclosing information in a clear, comprehensible, understandable manner. So there's 22 different types of saying this, let's say. And finally, I identified residual flexibility in the existing paradigm, which means that there are several entry points, according to my opinion, where we can adjust the information disclosed to the characteristics of the consumer or to the circumstances surrounding the contract. And the main advantage of this characterization was that it allowed me to establish a benchmark against which I later compared the information paradigm based on online reviews. Looking at the quality dimension of the information paradigm, once again, the literature has its own assumptions, and it assumes that the quality concern in the existing legislation is not sufficient, and it's actually quite rare. And I don't think this is entirely justified. Actually, I identified a variety and overarching concern with quality that stretches across different sectors and different contracts and goes beyond the typical principle of transparency, which is what the literature tends to focus on. For example, it covers duties to personalize, duties to explain, or duties to contextualize information to the consumer circumstances. But most importantly, I concluded that these concerns are not only individually relevant, but they show a systematic concern with quality, from which I believe it's possible to extract a principle of quality. And this characterization allowed me to conclude that the information paradigm already contains some solutions to the shortcomings that it deals with, including online review-based insights. So now talking a little bit about online reviews then, how can we frame them as precontractual information? First of all, I'd like to point out that they work as a complement of mandated disclosure. This means that if you remember the numbers that I cited at the beginning of this presentation, at the very least, consumers read both. They read precontractual disclosures and they read online reviews. However, it goes beyond that because empirical research shows that consumers, or 30% of consumers, tend to ignore trader-originated information and rely only on online reviews before making a purchase. And this is already a very important conclusion because it shows that there's a symbiotic relationship between top-down regulation and bottom-up regulation of consumer information. But now looking at what information is exactly conveyed through reviews, and we can make a parallel with what I just said about the information paradigm in consumer law, we see that it's mainly subjective information, mainly opinions, not always recommendations. They focus on user pattern aspects. They're very readable, which means that they rank very high on readability tests. And they also contextualize information. But most importantly, I think we have to focus on who controls information that is conveyed through reviews. And this is mainly twofold, in my opinion. First, consumers who act as true regulators. And secondly, traders and online platforms. And the image that you see now is a summary of my analysis on several terms and conditions and policies on online reviews that I collected from these 7 platforms. And the main conclusion that I extracted is that all these platforms exert at least some level of control over the information disclosed via reviews. And this is because not only do they prohibit that illegal content is included in online reviews, but they also have enforceable guidelines on what information or what content should be included in reviews. And this is just a summary, but from this analysis, I concluded mainly 2 things. First, online platforms via reviews, they behave as true gatekeepers of private information as well, not just public information. And secondly, through reviews, online platforms do protect at least some of the values pursued by EU consumer law when it comes to the regulation of information. So what are the main differences between these 2 paradigms? You probably guessed that both of them cover objective information on product service main characteristics. But the similarities stop here. So this is rather a residual overlap. Online reviews convey legally relevant information, but they miss out on a lot of important aspects. So for example, online reviews only cover 3 out of the 20 topics that EU consumer law believes consumers should be informed about. But on the other hand, online reviews also fill several gaps because, for example, they cover a variety of types of information that is not included in current disclosures in EU consumer law. In particular, they cover disclosures on user pattern information and advice. But I want to highlight that it's important to note the difference of behavior towards each source of information because consumers frequently say they don't have time to read terms and conditions, but empirical research shows that consumers tend to spend between 15 to 30 minutes reading reviews when they are about to conclude an important purchase. So, how can online reviews contribute to better regulation in concrete terms? First of all, as I said, online reviews are aligned with at least some of the values protected by EU consumer law when it comes to the regulation of information. And from this, we can conclude already that unlike what it's typically assumed in the literature, online reviews or private regulation do not always result in low levels of consumer protection. And from this conclusion, others follow. So because online reviews protect some of the values pursued by EU consumer law, I believe that they are a sufficient justification so that the legislator in the future shows some restraint in adding more information duties in certain contracts in certain sectors. However, because this protection is still incomplete, I believe that they're not a sufficiently strong justification that leads to an active deregulation of existing duties. On the other hand, I also don't think online reviews are a reason to increase or to add certain duties like duties to advice, even though that's their main or one of their main added values is bringing this subjective information into consumers' lives. But I do think that they justify the creation of supporting duties that relate to this capacity as online reviews as subjective information. For example, I believe that duties to mandatorily collect feedback from consumers could be justified, or duties to highlight the existence of reviews when they are there. But most importantly, I think that the most relevant role that EU consumer law can play when it comes to online reviews is to create incentives for First, its expansion. So online reviews are most typical in sectors like tourism and retail. And secondly, I think it's important to provide incentives for their robustness. And their robustness relates not only to reliability, but also to problems like their quality. And I think this can be achieved through regulatory intervention. For example, the legislator can say that a robust review mechanism can presume compliance with certain information duties or liability exemptions. I'm going to conclude my presentation. If you remember, I hope so, at the beginning of my presentation, I said that no solution has been found to the shortcomings of the information paradigm. And I think that's because there's no one solution for this problem. I think there's many. First of all, I'd like to remind that the EU law-based information paradigm already contains some solutions. So we do not have to look for a solution exclusively outside of it, nor do we have to pursue a structural change of the existing paradigm in EU law. Secondly, I did not aim in my research to provide a single absolute answer to my research question. I rather looked for the nuances and the possible answers, and I wanted to map which alternatives are viable and not viable for the role of online reviews. But I want to conclude on a different note. Online reviews are definitely a good, effective way of tackling consumer disinformation, but they're much more than that. They are a massive source of data on consumer preferences and consumer behavior. They are a tool, a trust mechanism that actively replaces public regulation in a lot of sectors. And they are an easily scalable, accessible tool that reaches millions of consumers every day. I truly believe that law has much to gain from awarding online reviews a more prominent role. Thank you.
Thank you for your presentation. And now the opposition will be opened by Professor Faure. Professor Faure is Professor of Comparative and International Environmental Law at this university and also the chair of the Assessment Committee. You have the floor.
Thank you, Mrs. Rector Magnificus. Mrs. Candidate, I have enjoyed reading your thesis. It is the kind of manuscript where when you start reading, at the beginning as a reader, you have some difficulties accepting the story, and you even may feel some internal resistance about what you're bringing, about the strengths of these online reviews. But then along the way, you see that the story is supported with razor-sharp analysis and an overview of empirics, and you become more and more convinced that the author has a point. In this case, trying to convince you that online review mechanisms can contribute to the information paradigm in EU consumer law. But Mrs. Candidate, you have confused me. And I hope that you can deconfuse me today. You know, your book is called Reviewing the Information Paradigm. That I still understand. And I know you like the word paradigm. I have not been counting, but I think it was more than 50 times that we heard the word paradigm, even now. And then I look at your research question. Your general research question on page 28 says, how can and should online review mechanisms contribute to the information paradigm in EU consumer law? I said, okay, so that's a one-dimensional direction. It is, I check whether the online review mechanism is contributing to the information paradigm in EU consumer law. Here, online review is called a mechanism, not a paradigm. But then, Ms. Candidate, one page later, on page 30 at the bottom, and also, by the way, all on your sheets, we're certainly talking about two paradigms. And then online review is also a paradigm, and it becomes an alternative for the EU information paradigm. And then, Mrs. Candidate, I am totally confused. And so my question is, what is then this online review for you? Or I should maybe put it differently, what is a paradigm for you? Because you use everything as a paradigm. Now you could say, okay, the highly learned opponent is interested in playing with words. It's only about whether it's a paradigm or not, and maybe I shouldn't call it a paradigm and a mechanism. No, it's more than that. If we are on page 28, it's one-dimensional. You say, I look how online reviews contribute to the information paradigm in the EU. So you accept the information paradigm in the EU, you look how online reviews contribute there. On page 30, and also on your sheets, it's different. It's alternatives. Alternatives means you cannot have two at the same time. So I enjoyed reading your book, but I was left in total confusion. And I hope that you can deconfuse me today.
Highly esteemed opponent, thank you so much for your very relevant and very interesting question. I think I understood your question correctly. I'm going to clarify why my choice of dealing with online reviews as a paradigm and why does my research question approach as a more monodimensional scenario according to you. So you identify something correctly. When I started researching online review mechanisms, and when I started doing research about this topic, and when I started reading or writing about this, I did not look at online reviews as a paradigm. I looked at them as a possible even replacement. I believe my perspective was a bit more aggressive. I looked at them as a bit more of a replacement, possibly. I remember that when I even wrote my research proposal, my original idea was online reviews convey subjective information. Can this subjective information replace what we do right now when it comes to the information paradigm in EU consumer law? And that was my original approach. And I thought, okay, let's look at this type of information that reviews convey, that is so different from what we're used to in the current paradigm or on the existing information duties. And let's see exactly as you said, monodimensionally, if reviews can replace it and if they're really in opposition. However, as time went by, I started to realize that online reviews are indeed not monodimensional. They are not just a source of subjective information as I was looking at them in the beginning, but they act truly as they are an exercise of private regulation, and they have many more dimensions than this approach of let's replace the information paradigm. We can either have one or the other. And that is why I chose the word contribute to the EU consumer law information paradigm. I rephrased my original research question, which mentioned, can online reviews replace the current information paradigm? Can online reviews, or is this approach better than the other? And I think I moved towards a more nuanced approach of thinking they are not in opposition. They can be complementary, as I mentioned also in my presentation. They can overlap in certain situations, or can they be opposites of each other in other situations? But because I wanted to explore all these relationships and not just the opposition relation, that was why I rephrased my research question. And then why I got to the concept of online review-based information paradigm, I will admit that was towards the end of my research. I believe that for the beginning, I think the first at least 2/3 of my research, I did not refer to it as an online review-based information paradigm. But more and more, so I'm sure that you are familiar, of course, with the information paradigm in EU consumer law, and it's called a paradigm because it is a model, standard model of action that permeates several fields, several directives, several contracts, and it's something that is also a typical method of action for the regulator, for the legislator. And so that was my starting point. My starting point of analysis of this topic was the information paradigm. How can we improve it? And then when I started looking more and more into reviews, I figured out, I think what we're talking about is not just one source of information that will influence consumer law or not. It is a true paradigm, because perhaps and I don't have an answer to this part. I don't know why consumers started reviewing in the first place. It's related also with the rise of the internet, and it started around the early 2000s. But perhaps this is not just a source of information. This is broader than that. This is a solution that consumers found to inform each other of information that they were missing from the current information duties. So this forms, for me, not in opposition, not in alternative, but a reflection of the information paradigm in EU law. So we have mandated disclosure, and this is also, I think, part of my answer to your question is that I am comparing two different levels of regulation. I call it an intra-regulatory approach because on the one hand, you are looking at what should be disclosed, and online reviews are what is actually disclosed. So it's a different, it's not a normative level, let's say. And I figured out, well, this is an alternative way of approaching the information paradigm. Consumers found a way of sharing and receiving information that they need in order to conclude contracts. And I thought we can truly talk about an information paradigm because this is not a one-time situation. This is something that has been growing, evolving, becoming stronger, spreading across contracts, spreading across sectors, and truly informing decision-making in several dimensions, not just in contracts, but it also works information or online reviews also work as reputation quality cues. They inform decisions on all sorts of sectors. And I thought this is not one-dimensional. This should not be addressed as just one source of information or as in opposition to the information paradigm, but it is truly an information paradigm from also we can learn. I don't see why they would be in opposition to each other. I truly believe that we can learn and this from the perspective of EU consumer law from online reviews. I hope this answered your question.
Thank you very much, Mrs. Candidate. I'm now at least confused at a higher level.
Okay, thank you. The opposition will now be continued by Professor Bush. Professor Bush is Professor of European Private Law, European Business Law, and Private International Law at Osnabrück University. And I wish you a very warm welcome here in Maastricht online, Professor Bush. Professor Bush is also a member of the Assessment Committee. And you now have the floor for the question.
Thank you very much, and thank you for the pleasure and the privilege to participate in this PhD defense remotely. I would have loved to come to Maastricht, but it's great to join remotely. I can join in with Professor Faure that I really enjoyed reading the PhD thesis, which deals with a very relevant topic, considering that information duties, disclosures are the preferred tool of EU consumer law. And I think let's say, a pertinent addition that brings this book to the discussion is widening the scope beyond the mandatory disclosures and exploring the possible added value of online reviews. Asking the question whether consumer information can be crowdsourced, whether crowdsourcing could be an approach to consumer information. This being said, I'm a little bit concerned about the future of the information paradigm and how technological changes in digital marketplaces might question the basis of the information paradigm. Why? Because the information duties that we see in EU consumer law today are directed at consumers, are designed with human consumers as addressees. But we might see as new participants in the marketplaces so-called algorithmic consumers. That could be smart home appliances, or simply human consumers that are assisted in their contractual decisions by virtual assistants, by automated decision-making systems, ADM systems. And my question to the candidate would be the following: how could the rise of such algorithmic consumers change the information paradigm? Will there be a need for more or less information, different types of information, or maybe information to be conveyed in a different form? And what would this mean for online reviews as a source of information?
Highly esteemed opponent, thank you so much for your questions. If I understand correctly, so there are two parts to your question. First, how can the rise of these actors related to algorithmic development of contracting impact the future of pre-contractual duties to inform in European consumer law? And second, what would this mean for the future of online reviews? So it touches upon both dimensions of my research. This is truly an interesting question, and one that I've certainly thought about. First of all, and my answer can be quite extensive in this, but first of all, the existing of information duties, whether we would have more or less information duties, these consumers, I am not sure, well, they would, I guess, first of all, we would need to, I guess, enlarge the concept of consumer, because the concept of consumer right now talks about a natural person that acquires products for reasons outside of their profession. Whether this would be a natural person, I would have my doubts, but we would have to think about it. Also, depending on how we, in general, frame these smart home appliances that would buy things for us. The concept question is the first question, whether they would be consumers or not, or whether consumer law would apply. I believe that this is not clear. So on a first instance, I'm not sure whether pre-contractual duties would apply at all. But let's say that the concept of consumer is enlarged and that they would fall under the scope, whether we would need more information or not. At this second stage, I believe that we also have to think about why we have, first of all, EU consumer law, and what is the main reason behind pre-contractual duties to inform right now. And the literature is quite unanimous at this point. I think it's because we're fighting information asymmetries and we're fighting imbalances of information. And this is something that I also found in my observation of 1,500 information duties, that all across these directives and these regulations that I looked at, while there is some flexibility, for example, when it comes to the level of information that the consumer is presumed to know, one thing that is always common is that the consumer is always presumed to know less than the trader. Even if we all probably know situations where this is not true. There are situations where in practice, the consumer might be more knowledgeable about the topic than the trader. But this isn't irrelevant because consumer law applies regardless, and information duties would still apply to the contract. I believe that in a first instance, these algorithmic ways of shopping or smart home appliances, I'm going to focus on this example, we would have to question whether these appliances would indeed need, or would there indeed be an information asymmetry. That would depend on the information that these systems can access. That would depend on how much information these systems have on consumers, because another reason why we have pre-contractual duties to inform, I mean, related to the imbalance of information, is of course that consumers act under biases. That it has been shown that algorithms can also of course act under biases, but that would have to be, we would have to look at the concrete case. But so depending on whether or not we would have an imbalance of information, we would see whether we still need to apply or to have information duties there. So I would tend to think that that would lead to quite a not radical change, but we would have to really consider whether we would put these sort of algorithmic shoppers under the concept of consumer. But at a second instance, besides wondering whether there's an imbalance of information, and this also connects to the reason why I looked so much into the quality framework in European consumer law, because I wanted to know how flexible consumer law is to these future developments. And this does not only concern algorithmic shoppers, as you mentioned. I'm sure you're also referring to other digital problems or digital transformations that are coming. For example, the metaverse. I have a lot of questions on how this would apply, or consumer law would apply to the metaverse. This actually also relates to the second question, your second part. I feel like the metaverse is an example of how these two realities, let's say in consumer law, so consumer law duties and online reviews would converge. When I first started researching about online reviews, I always referred to or thought about the Black Mirror episode Nosedive. I don't know if you have it present. It's the episode where this woman or the society just rates everything they see, and not only are interpersonal connections based on these reviews, access to certain products and services is also determined by reviews. And at the time, I remember I had some conversations with some people who probably thought I was crazy, but they said, this is never going to happen, and this is really utopic, and this is never going to happen. And I think the metaverse is it's a step towards that sort of situation. I think that's also why online reviews and the study of online reviews, not only in connection with pre-contractual duties to inform, but also independently, is absolutely crucial for law right now, because these sort of developments are coming, as you correctly mentioned in your answer. Not only the metaverse, but for example, we are living in an increasingly digital society, and this sounds like one of those very generic sentences, but with COVID, we became even more digital. Contracts are more digitally concluded. There was a rise of 25 to 30% in reviews posted. So contracts are developed more and more based on reputation, on reviews, on the information that is shared between consumers. So partly to answer your question, I think that developments such as those that you mentioned only mean that online reviews will become more relevant. Online reviews, if we're talking about algorithmic actors, online reviews can also be used a bit like what I was saying in the beginning, as a repository of consumer information, because you can extract a lot of consumer patterns, a lot of consumer behavior that these algorithms would and are able to do. So that would not only inform the knowledge or the amount of information that these mechanisms have on the consumer that they're, let's say, working for, but also on consumer behavior in general. And also, again, to bring back to what I was saying a bit earlier, this is the reason why I looked so much into the quality framework in EU consumer law, because I wanted to see how future-proof it is currently, how open it is to certain solutions that have been suggested in the literature. So the literature has suggested many, many ways of tackling these shortcomings, going from legal design to personalized disclosures, to reducing the information paradigm, to abandoning the information paradigm. But my focus, and I don't know, I think that's clear in my research, my focus was mainly the digital world. So what I concluded based on the existing quality framework is that there is some opening based on which we can in the future adjust information duties to these technological developments, not only digital, but also related developments. So I hope that answered your question. I'm happy to elaborate some more.
And no, if
I cannot. Okay.
Even if not, I am not going to allow you additional time. So the opposition will now be continued by Professor Mak. Professor Mak is Professor of Civil Law at Leiden University, so very much welcome here in Maastricht, live even. Professor Mak is also a member of the assessment committee.
Thank you. Dear candidates, congratulations on writing a wonderful book. After the last answer, I'm very tempted to continue asking about Black Mirror episodes, but my question concerns chapter 5. In that chapter, you show, I think, a great skill for a legal researcher, namely the ability to draw more general conclusions from research of different empirical studies and the scattered rules of information duties in the consumer directives of the European Union. And I think it's a great skill to be able to draw such general conclusions on the basis of your thorough research. It's also not an easy thing to do. And I'm wondering, can we really say that there is a principle of qualitative transparency following from your systematic and teleological interpretation of existing EU law? Now, I read a few things in your chapter. You say that the modalities of transparency, such as clarity and the use of plain and intelligible language, are duties considered independently, albeit that they are interpreted uniformly across directives. So that's one step. But is it enough? You also discussed the attempt made by Wilhelmsson and Dick Flesner in relation to the Draft Common Frame of Reference, the DCFR, to establish a general principle that information should be provided in clear and intelligible language. You say that on page 168. These two authors ran into a limitation, namely that it is hard to generalize principles from scattered rules that apply only to certain contracts and certain situations. You also concede that the epistemological vagueness of this endeavor still exists, where I'm thinking, well, basically we only know whether something is a principle because the European Court of Justice says that it is a principle. But do we know how the court gets to establishing such a principle? And so my question to you, can you elaborate on how you deducted from your analysis of these scattered information duties that there is a principle of qualitative transparency, or can you defend that there should be such a principle?
Highly esteemed opponent, thank you so much for your question. I think I understand it correctly. You're wondering about the foundations and my base arguments for claiming that there is a principle of quality in EU consumer law when it comes to the pre-contractual information. That is a very interesting question. It's definitely one that I thought about a lot. I think chapter 5 was probably one that I think that I spent the most time in, and the one that I certainly took me to deeper dimensions of consumer law. As you correctly pointed out, it's not an easy exercise, and it was probably one of the hardest exercises in my dissertation. Probably one of my favorites as well, because it made me to really question the basis of consumer law and how to extract principles and whatnot. I would like to first explain that the principle of quality, from my perspective, it's not only normative in the sense that I think that there should be one, but it's mainly descriptive. So what I didn't set out to write a chapter looking for principles of information. I was researching all these 1,500 information duties, which is how I started. I started by mapping all of them. And then I identified not only at several dimensions, which I will elaborate about in a bit, but also across different contracts, different sectors, different directives, a concern with the quality of information. And I'm sure you're aware, or rarely does the legislator say, we are concerned with the quality of information. This duty is about the quality of information. So for example, if there are duties to explain in the Mortgage Credit Directive or the Consumer Credit Directive, the duty is phrased as the trader must explain to the consumer the consequences of this contract. So it's not explicitly associated with quality. So I think, as also you implied in your question, this jump from that I extracted, for example, from duties to explain to a concern with quality is purely mine. So this is not something that the legislator, it does hint at that, but it doesn't explicitly make this connection. It is true that the principles are mainly identified by the Court of Justice, but I think that's more an instrumental perspective. So they might already be there, but it's more an enunciative perspective. So the Court of Justice kind of declares that they are here. Not that I think that I'm the Court of Justice in any way, but by analyzing, as I said, not only multiple dimensions, but several, not only multiple contexts, but several dimensions, I reached that there's an overarching concern with quality. And this came from, first of all, the variety of or the different types of information whose disclosure is mandated. It's true that there's not a lot of duties, there's mainly duties to inform. And I have to say, before I also go deeper into this, my hypothesis was the opposite. So my hypothesis when I started to research this was the quality concern in EU law is very low. I'm probably not going to find much, and I'm going to criticize this, and I'm going to say that we need a reform and we need to revise this. So it really, I don't think it was confirmation bias, because that would be hard, given that I was assuming the opposite. And then I started to identify a lot of duties to explain, and then some duties to advise. And then more than duties to advise, I identified a concern from the legislator in delineating the relationship between explanations and advice, or information and advice. So there's a concern with explaining a personal recommendation should not be given. This is different than an explanation. And I thought, okay, this also shows a concern with advice. Then I identified, as I said in my presentation, some residual flexibility of the information paradigm in consumer law, which, and this is also, I explain about this in my book, of course, but there are several instances where I see that the context surrounding the contract influences the information that should be disclosed to the consumer. And this covers not only, for example, the medium used to write the contract in or to write the pre-contractual information in, but also the main characteristics and limitations of the consumer. For example, I can also relate this to the duty of explanation that I was just referring to. Often there's not just a duty to explain to the consumer, but there's a duty to explain taking into account the financial literacy levels of the consumer. So taking into account the qualities of the consumer. And it's true that duties to explain are mainly contained in some directives, so they're mainly true for the financial sector. It's also true that this heterogeneity of quality concerns is mainly present in the financial sector. But I found, again, this residual flexibility is scattered across all directives and regulations that I analyzed. And also from, I think, what you were referring to, the different modalities of transparency, the fact that the legislator doesn't only say the consumer should get clear and comprehensible information, but it says this in 22 different ways, which I must rephrase. I don't think it says the same thing in 22 different ways. That was also my point, that there are different ways of saying this, and I thought, okay, there's an overarching concern with quality, that's for sure.
Could I ask you to come to a conclusion?
I can. Sorry, yes. And then I thought, but then I applied the methodology or some steps that I saw from Schulze, And I thought maybe this overarching concern is not only about teleologically and systematically how they are, or legislators concerned with quality, but following all these steps, I thought, okay, there is a true principle of quality, and this principle of quality has added value for European consumer law. Yes, I'm done.
Thank you. Because the opposition will now be continued by Dr. Kaufmann, who is Associate Professor of Private Law at this university and a member of the Assessment Committee.
Yes, thank you, Mrs. Prorector. Dear candidate, dear Madalena, you wrote an outstanding PhD thesis. By combining empirical and traditional legal research methods in an original way, you shed light on the relationship between online consumer reviews and the traditional information paradigm and how they complement each other. You analyzed the massive amount of information and presented your analysis in a way that encourages the reader to keep reading and that leaves him disappointed when you indicate that you cannot further elaborate on certain issues. In the light of this, you will not be surprised that my question relates to one of those issues. In particular, my question relates to Chapter 7 of your thesis, and it concerns the relationship between online consumer reviews and the existing rules of contract and consumer law. In Chapter 7, you rightly pointed out that it was not possible to discuss all elements of this relationship. However, since I find this relationship very intriguing, I would like to use this defense to hear your opinion about some additional elements. I noticed in the examples you discussed that you focused on cases where the information given in the review was false, and you investigated the rights the consumer could exercise when he made a decision based on false information. But what if the information contained in the review is true? Could the consumer's rights be impacted by the fact that the consumer did not take into account a large number of negative and true reviews and warnings on the website? Let me give you a concrete example. A few days ago, I was looking to buy a flashlight, and the product description given by the seller mentioned that the flashlight had very high light output and that the bright light can even be further bundled, creating an amazing beam of light. But the site also contained many negative reviews, describing the product as being of only moderate quality, providing little light, mentioning that it gives light for only 10 seconds, and even describing the product as pure trash. Imagine that I buy the product and complain afterwards about a misleading commercial practice or a contract concluded on the basis of a mistake. Could the reviews be used to support the view that an average consumer would not have made the same mistake, that I failed to carry out a duty of investigation or something similar? Or by contrast, could the reviews be used to argue that those writing the reviews also bought the product, and that this exactly proves that the average consumer would have made the same mistake? I look forward to your answer.
And could I ask you to try to be brief?
Yes. Thank you for the warning. Esteemed opponent, thank you for your question. Again, very interesting. It's also something that I thought about. It's also something that I approached, but had to not include in my PhD. Otherwise, it would become a treaty on contract law of online reviews. If I understood your question correctly, or the main example is a case where the trader information is misleading, but reviews are pointing out to that problem. So they're saying, you know, watch out, this is not true. The flashlight is not amazing. So I do agree with you. If we're looking at mistake, And bear in mind that in my thesis, I looked mainly at mistake and at a breach of contract, rules applying on breach of contract. If we're looking at mistake, I do think that that can be used as to justify the existence of a duty to investigate, or in my thesis, I placed it on the requirement of excusability. So whether it's excusable that the consumer was mistaken by this true information, by this false information from the trader, when the consumer could have easily checked negative reviews. Of course, this depends on the concrete scenario. In your case, I'm assuming that it's a consumer who has digital knowledge and concluded the purchase online, so has access to these reviews. This is my opinion. I don't think that legally or at a court this would be so clear. This is also why I believe that we should impose a duty, or should expand this duty to highlight the existence of reviews when consumers are concluding purchases online. Similarly to what happens, for example, when you're purchasing something online, EU law says that not only do you have to be informed about the price of the product that you're buying, but you have to be informed of that price moments before you conclude the purchase. So I believe that a similar duty could exist, where consumers have to be informed of the reviews or ratings that exist, not only because this would lead to better informed consumers, but exactly because of contract law reasons. So this would allow us to strengthen the contract law framework that surrounds reviews, which, as I say, my dissertation is not very strong and it has a lot of flaws. And before I conclude, I want to also highlight, you mentioned the average consumer. This is another way that, unfortunately, I could not explore how to materialize, but I believe that online reviews can materialize the vague and artificial concept of average consumer in two ways. Not only because consumers can access online reviews to get informed about the purchase that they're about to make, and then we can see, okay, the average consumer would or would not have read these reviews, but as a source of data on consumer preferences, we can actually analyze thousands of reviews, millions of reviews, and extract an image of the digital consumer nowadays. The digital consumer values information on this and this. The digital consumer does not seem to know about legal rights before concluding the contract. So I thank you for touching on that, because that's another way I think online reviews can contribute. Yes, I thank you. I hope I answered your question and I wasn't too long.
So the opposition will now be continued by Dr. Leszczyńska, Assistant Professor of Empirical Legal Research at this university, member of the Assessment Committee, and with us from New York. Dr. Leszczyńska, you have the floor.
Thank you very much. Thank you for giving me the opportunity to not only read the dissertation, but also to ask a question. Dear candidate, I would like to join the other members of the committee in congratulating you on such wonderful work, such wonderful research that you conducted. In particular, I very much enjoyed the empirical part that I think makes a wonderful contribution not only to the legal scholarship, but can be very useful also to businesses, to companies, and if I understood correctly from the dissertation, there is a plan to make the results of your empirical research also available to companies, that they could access and get an overlook of all the information duties that are imposed on them by EU law. So very much impressed by this work, by this description and systematization. I think that's very useful. Now my question will, I really enjoyed reading all the chapters until I reached chapter 7, where I got quite a lot of concerns about the conclusions from this chapter. So in chapter 7, you not only start with the analysis of how online reviews and the information provided there could be enforced by contract law, but you also conclude this chapter with making some recommendations on how EU law could incentivize, for instance, more reviews in specific sectors, or how it could also interfere with platforms' oversight of the quality of these reviews. Or intervene in how platforms conduct their oversight of the quality of the reviews. My question here is that in your presentation, but also in the book, you several times mentioned that the online review mechanism is a trust-based mechanism, and it's a market-based mechanism. So the enforcement of the information provided in the reviews is based on reputation, on the perspective of long-term exchange between consumers and businesses. My question now to you is, how do you think the contract law enforcement, but also these EU law-based regulations could potentially interfere with these trust-based enforcement mechanisms and reputational mechanisms? Just to give you an example of more concrete question and possibly a prediction or intuition that you could give us here, how do you think consumer will behave when they write such reviews, when they know that they can be contractually enforced? How the platforms will react in the oversight over these reviews or incentives that they provide if they know that they are legally expected to encourage the reviews of financial products, for instance? I know that it's a complex question, but I would like to hear your intuition here. What kind of interactions you would predict between these market-based, trust-based enforcement mechanisms and the law-based enforcement mechanisms that you suggest in Chapter 7?
Esteemed opponent, thank you so much for your question or questions. It's also a very interesting question. I think I said that about everything, but it's true. And I've also thought about that a lot. I think Chapter 7 was the most fun to write because it was the one where I felt like it's the conclusion of my PhD. I'm going to think of what possible scenarios, not just one scenario, but what possible scenarios online reviews can impact the information paradigm. And then again, this multidimensional framework where it's not just they can justify increasing some duties or decreasing some duties, but they are already, but only by existing, they are already impacting the relevance of mandated disclosure, the role of regulators or the perspective of regulators on disclosure, and the role of platforms. So how contract law enforcement would interfere with these trust-based mechanisms? Well, a contract law framework is already applicable. And that's what I was trying to show, of course, to a limited extent. And my perspective when looking at a contract law framework was mainly that of looking from the consumer perspective. Can we extract more rights? Is it useful to invoke this contract law framework rather than just relying on consumer law for the consumers? But for platforms, if you look at terms and conditions of that are regulating online reviews, and to talk about more broadly about you asked about trust mechanisms, and I believe that trust mechanisms go beyond what I looked at in my research. So I looked mainly at, for example, transactional written reviews, and I didn't look so much at the impact of ratings. For example, in some platforms we only have a rating, or we only have a percentage, like 94% of consumers like this product, or 94% recommend this product. That's a quality cue, and it's more reputational than or the reputational dimension is stronger than a written text online review transactional mechanism, which was the ones I looked at the most. But the terms and conditions of platforms right now already have a lot of obligations, what I interpret as obligations that apply to consumers. So you're asking me, how will enforcement or contract law enforcement affect consumer perception and platform perception in this kind of relationship of power, and also in the regulation of information? That already happens because they have a lot of these, and a lot of my, I also wish I hope in the future I can spend more time on this, but looking at the nature of these guidelines available on online platforms. A lot of the times, and this is regardless of whether they are called guidelines or terms and conditions or whatever, but the way they phrase it, it always sounds like it's nice and friendly and it's just a suggestion and just a guideline. But my conclusion was that most of these, or a lot of these norms, I'm already giving away what I think, a lot of these norms are actually rules. So they have normative power, they are enforceable, because most of the times, of course, always depending on the context, but you are concluding a contract with the platform, between consumer and the platform. So I believe that this already impacts I don't think much will change. Then the second aspect.
You can take the time to finish the question, the answer.
Yes, thank you. The second aspect, which I think will change from a regulatory perspective, how enforcement is perceived and the role of platforms in this trust game is the DSA. The DSA will bring a lot of different aspects to the table. I'm happy to talk about this with you at another point, but I think that has a strong impact on the dynamics that will happen in this field of reputation. Thank you.
Okay, thank you, excellent. Madalena Narciso. The time appointed for defending your thesis has now passed. The degree committee will withdraw to discuss the quality of your thesis and your defense. I request that you and your company await the results of our deliberations and our return in this room. Mendonça Narciso. The degree committee here present has assessed the quality of your thesis and of your defense, and in view of its positive verdict and taking into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professor Smits is now authorized to confer upon you this academic distinction in accordance with Dutch university custom. I invite your supervisor to now take the floor.
Madalena, I first have a question for you. Do you promise to work in accordance with the principles of scientific integrity at all times? To be careful and honest, to be transparent, to be independent, and to be responsible?
Yes, I promise.
By the authority vested in us by law, and in conformity with the decision of the committee here present, I hereby confer upon you, Maria Madalena Barreto Torres de Mendonça Narciso, the degree of doctor, and grant you all rights attached to this by custom and law. As evidence of this, I now present you with the degree certificate signed by the rector, the secretary, and the other members of this committee, and affixed with the official seal of the university.
Dear Dr. Barreto Torres de Mendonça Narciso, and I realize that this is the first time I actually pronounce your full last name complete. Dear Madalena, you did it. You have managed to written a wonderful thesis on a key topic in the field of consumer law, the information paradigm. As we have also learned today, you have looked at online reviews from a consumer law perspective and contrasted it to the EU information paradigm. You took as a starting point the observation that consumers do not always receive the right information when, for instance, purchasing a product or a service, and that if they do receive the correct information, they often do not know what to do with this. Your hunch was that online reviews could shed light and new light on and provide new solutions for ensuring that consumers receive more useful information and or that they can better process the information presented to them. Your research originated in Tilburg, at Tilburg University, where you did your research master. And under the supervision of Vanessa Mack, one of your opponents today, you wrote a thesis titled Pre-Contextual Information Duties versus Online Reviews, which will rule over the platform economy. The role of online platforms and online reviews in consumer law. So you already see back then you used a lot of words sometimes. And back then you concluded that online reviews, and I quote, online reviews can be perceived as a possible solution to the information paradigm's limitations. Now, today, your conclusions are much more thorough and nuanced. For instance, you find that the fact that online reviews are being perceived as recommendations from a friend cannot be replicated in the information paradigm, and that the scope of protection offered by the information paradigm and the online review paradigm is different because, among other things, online review mechanisms are particularly common regarding lower value and non-financial transactions. As already mentioned, you have introduced a novel perspective. The systematic overview of the EU information paradigm and the confrontation of it with online reviews is an original perspective that you were the first to explore. Also, the insights your research has produced are novel. Contrary to what we believed in the beginning, it turns out that there's actually overlap, or at least more overlap, between the information paradigm and the online review paradigm. In fact, some of the types, as you explained, of information that online reviews aim to convey can also be found in parts of the EU information paradigm. As we have witnessed today during defense, the analysis gives rise to additional questions and sometimes to a bit of confusion and maybe also de-confusion. And this is inevitable if you try or do something new, which is what you have done. What is also novel is the empirical approach that you took. You went through approximately 1,500 pre-contextual duties in selected EU consumer legislation and 420 online reviews spread across 20 products, with the goal to measure how frequently you encountered which quantitative approaches, so the amount of information, and qualitative approaches to information, essentially how valuable and understandable the information is. You operationalize the two theoretical concepts in a number of empirical variables, including the object nature and category of the information duty, the type and transparency of the information, the modality of transparency, and whether the information is personalized. And this has led to many tables, various analyses in SPSS, statistical software package, to data sets, and to code books. And this is all jargon that is still not very common to the legal academic community, but very common to you in your PhD, but already prior to your PhD, you were familiar with these terms. And you've made all your materials available, thereby adhering to the FAIR principles, and not fair in terms of legal sense, but fair in terms of findable, accessible, interoperable, and reusable. And more importantly, you have conducted true interdisciplinary research, integrating an empirical perspective and analysis in a legal analysis in order to generate substantively relevant insights in the field of consumer law. Now, did this all come natural? In most PhD researchers, the answer is no. However, in your case, and I also speak on the behalf of Jan, I'm inclined to say that it did come natural. You are one of those students who writes a PhD thesis regardless of their supervisors and not because of their supervisors and their help. Maybe that says more about us than you, but it also says something about you. So of course, the analysis always takes longer than one wants or expects them to go. And it can be frustrating to have to teach when you're in a flow and you just want to think and to write. But even in those moments, we sense the eagerness and motivation of you to do your research while teaching, something you love to do as well, the teaching that is. A colleague back in the days, also present here, I won't reveal his name, described you as a tornado. And that's not because you are a destructive person or because you have a destructive personality, but because you blow away, and back then you blew away the committee members that assessed your research proposal when applying for a PhD at Maastricht University. And this is something Jan and I also got to experience, and I think we've also seen a bit of that today as well. I actually got a bit concerned for the microphone that it wouldn't blow up because it would be overloaded sometimes with the number of words and the frequency that's coming at them. Your enthusiasm and drive are infectious and have definitely been instrumental during the process of your PhD. In your foreword, you mentioned that it was the right decision to do your PhD in Maastricht for professional reasons, but also for personal reasons. It was definitely the right decision for us, Jan and myself, for the department and for the faculty as a whole to have offered you this position. It was an absolute joy for us to supervise you. One thing, however, was a struggle, and that was the 2 times you got stranded in Portugal. You ended up staying with your family for months longer than expected because of lockdowns that were imposed exactly at the time that you decided to go to Portugal. And after that, I advise you not to visit Portugal anymore in order to avoid future lockdowns. But unfortunately, by then you had mastered the difference between correlation, Portugal, and the accidental happening of lockdowns, and causation, the lockdowns as you going to Portugal. So jokes aside, it wasn't not easy to have, even though you very much love your family, work for months on end in an environment that was not your natural habitat. Nevertheless, the chapters kept coming, and not only the chapters. You have published at least 4 journal articles, have produced 2 working papers on consumer law related topics. And in addition, you have attended various conferences, not only as an attendee, but also as a presenter. And how this was presented to us supervisors often went something like, somewhere during a supervision meeting or an email, an article that I wrote got accepted. And of course, Jan and I were very proud of you, not only for the output, but also of the fact that the publications came in highly respected journals. But admittedly, it also sometimes left us with a bit of an awkward feeling. Because Jan and I looked at each other and we said, did you know she wrote an article? Did you know she had a presentation? Should we not have been more on top of these activities? I ask ourselves and each other. But it does go to show how you not only be able to successfully conduct and complete your PhD thesis, but also that you have become an independent researcher. And rather than feeling awkward as supervisors, we mostly are extremely proud of what you have learned and what you have become as an academic, but also as a person in general. Now, years ago, when I was teaching empirical legal research at Tilburg University, there was a student who, in the course of only a few months, went from no knowledge about empirical research to someone who conducted an experiment according to the state of the art in the social sciences. In the experiment, you tested whether consumers, individuals, had different expectations regarding their legal rights when comparing free versus paid apps. Fun fact is that this research is similar to the research of one of your opponents, Monika Lashinska, who received a large European grant to analyze the effect of offering content for free influence consumer behavior. It made me realize that today you have become full and you've came full circle. Madalena, also on behalf of Jan, congratulations to you, your parents, your family, friends, colleagues, and you have made many, and others who have supported you throughout and have every reason to be proud of you. And of course to Matti as well. Well done.
Dear Dr. Barreto Torres de Mendonça Narciso, I'm only going to say this once, dear Dr. Narciso. It's an honor to be able to congratulate you with the degree that has been awarded to you, also on behalf of the rector and on behalf of the Board of Deans. It's the highest degree that we have available in this university, so congratulations on that. Now, you are very lucky because since the measures have been lifted, you're able to have a reception. So what we're going to do is I'm going to ask your company to leave this aula and to already move to the room where the reception will be held, because we are going to stay here in the aula so that we have a photo opportunity with the external members of the committee, and then we will join the company in the reception room. So on this, I would like to end this academic ceremony.